Good morning, everyone. Thank you for joining us for today's webinar for your ethics CLE point, falling short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. My name is Jennifer Shaw. I'm a partner at Bartier Perry, and I'm in the dispute resolution and advisory team. I also I'm a member of the Professional Conduct Advisory Panel, and I act for and assist solicitors in relation to complaints and related disciplinary proceedings. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to the elders, past, present, and emerging. So before I get started, I just wanted to run over a few items so you know how to participate in today's event. You'll have the opportunity to send through some questions at any time, and I'll endeavour to answer those towards the end of the presentation. You can use the control panel for that. You'll also receive a copy of these slides and a recording of the presentation after the webinar. Finally, we do like to get your feedback, so if you're able to complete the exit survey at the end and send that through, that would be great. So just briefly, I'm going to firstly run through a quick refresher of the meaning of professional misconduct and unsatisfactory professional conduct, as those terms, I'll be referring to those terms in some of the cases that I'll talk to you about. I'll discuss which types of complaint can be determined without referral to the tribunal and the sorts of cases that end up in the tribunal. And then I'm going to run through some recent interesting disciplinary decisions, and we'll have a look at the lessons arising from those. So those are cases from the last year, or 2021. So starting with the definitions of UPC and PM. UPC is conduct occurring in connection with the practice of law that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. And professional misconduct is a substantial or consistent failure to meet that same standard. It's also conduct occurring whether or not in connection with the practice of law that, if established, would justify a finding that the lawyer is not a fit and proper person to engage in legal practice. So it's pretty easy to follow that a consistent failure can occur where we have multiple instances of UPC, and that can of itself amount to PM. But what does a substantial failure mean? Well, the Court of Appeal in this case said that a substantial failure directs attention to the nature and consequences of the failure, which may be sufficiently serious to raise questions as to the lawyer's competence and diligence, and thereby warrant the description substantial. And in this case, substantial was held to be, the court said that substantial should be taken as referring to a failure to meet the requisite standard in a way that's meaningful or relevant to the legal practitioner's ability to practice law. So here we've got the summary of the usual steps in the complaint process. So firstly, well, an individual, or sometimes the Law Society or Bar Council, will make a complaint about a lawyer to the Legal Services Commissioner about the conduct of a lawyer. So the lawyer will first receive a notification of the complaint, and there usually then follows an investigation, either by the Legal Services Commissioner, or it may be delegated to the Law Society or Bar Council for investigation. The lawyer is invited to make submissions in response to the complaint, and eventually the lawyer will be notified of the outcome of the complaint process and what actions proposed to be taken. Now, if it's proposed that disciplinary action will be taken rather than the complaint just being closed, then the lawyer will be afforded a further opportunity to make submissions about that proposed action before the matter is determined. So under Section 299 of the Uniform Law, the local regulatory authority, so Law Society or Legal Services Commissioner, for example, has the power to make findings of UPC and has the power to make various orders under Section 299. Now, they're not all listed here, but these are ones that I often see. They can issue a caution, a reprimand, they can require a solicitor to make an apology, they can require a solicitor to undergo further education. The ones I usually see are education in relation to trust accounting and ethics, and they can issue fines. So Section 300 provides that proceedings can be initiated in the tribunal if the local regulatory authority, so again, Legal Services Commissioner or Law Society, for example, are of the opinion that the alleged conduct may amount to UPC that would be more appropriately be dealt with in the tribunal, or if it may amount to PM. So it's the more serious types of conduct that are referred to the tribunal to be determined. Now, what's the purpose of disciplinary proceedings? Well, in this case, it's important to remember that disciplinary proceedings are protective, not punitive. So they're not actually intended, although it might feel like it, to punish lawyers. And in this case, they explained it in this way. The Court of Appeal considered the ways in which the protective purpose of disciplinary proceedings might operate. First, by its direct effect on the practitioner. The order will either remove that practitioner from membership of the profession or will provide a deterrent against the repetition of such conduct, so by a fine or reprimand, for example. There are also important but indirect effects to be considered. First, the order reminds other members of the profession, of the public, and other members of the profession and of the public interest in the maintenance of the high standards of professional standards. And secondly, and more specifically, it may give emphasis to the unacceptability of the kind of conduct involved in the disciplinary offence. And thirdly, by speaking to the public at large, because these decisions are public decisions, it seeks to maintain confidence in the high standards of the profession. So now we know what types of cases are referred to the tribunal and the purpose of disciplinary proceedings being protective, not punitive. I'm going to run through some recent disciplinary cases from 2021, which will give you a flavour of the types of cases that are considered more serious and that are referred to the tribunal for determination, and also the types of orders that the tribunal make in those cases. So in this case of Zhu, the grounds of complaint were that the solicitor had falsely purported to witness the signature of her client on an e-affidavit. The society sought professional conduct finding, or UPC. They sought a reprimand and a $3,000 fine and costs. So in this case, the solicitor had been retained to prepare a joint divorce application for a husband and wife. The husband and wife had signed an affidavit in the solicitor's office, and that was correctly witnessed. But then the solicitor prepared an e-affidavit and emailed it to both the wife and the husband. And the solicitor knew by this stage the wife had gone overseas. The wife signed it whilst overseas, emailed it back, but she didn't sign it in the presence of the solicitor. The husband signed it in the presence of the solicitor, but the solicitor signed as witness to both of those signatures, notwithstanding she had not witnessed the wife's signature, and she filed it in the family court. So the solicitor said that she had a lack of familiarity with the detail of family court forms. She thought the original affidavit signed by the husband and wife wasn't suitable for e-filing. The e-affidavit actually didn't differ in any material particular to the affidavit that had been correctly sworn. And she argued that the original correctly witnessed affidavit she subsequently discovered would have been accepted for e-filing. She said she knew that the wife did not sign the affidavit in her presence, but her understanding at the time was that the purpose of witnessing was to ensure the signature wasn't forged. She therefore represented that she had witnessed the wife's signature. She said there was no intention to mislead the family court, and she didn't understand that the witness must observe the signature being placed on the document. So the legal question in this case was whether in all of those circumstances, this solicitor's conduct in signing this document as a witness when she did not see the person sign, whether that constituted PM or the less serious UPC. So in other words, was her conduct merely a failure to reach or maintain that reasonable standard of competence and diligence, or was it a substantial failure? Well, the solicitor argued this was UPC. She said she correctly witnessed the first original affidavit. Office was closed for Christmas, so she couldn't speak to a colleague to check. She incorrectly thought she had used the wrong form. Client was overseas at the time, and the affidavit filed replicated the original affidavit that she had correctly witnessed. And there wasn't any suggestion that the wife's signature was forged. There wasn't any benefit gained and no loss suffered. So in making the findings, in terms of the tribunal's findings, the tribunal said that in cases of false witnessing, it's usual to make a finding of PM. But characterising the conduct depends on the tribunal's assessment of the particular facts and circumstances of the case. The tribunal held that under cross-examination, this solicitor demonstrated she actually did understand what was required to properly witness and had that understanding at the relevant time. And the solicitor had agreed due to pressure from her client. Tribunal said that pressure from clients and embarrassment are not and cannot be excuses for lapses in compliance by lawyers with their professional conduct obligations. So, in making a finding of UPC, the tribunal said that it was satisfied that this was an isolated lapse by the solicitor and that it was unlikely she would ever err in the same way again. The tribunal took into account her experience and that she had acknowledged that her conduct was improper. Nevertheless, the tribunal said that witnessing documents is a fundamental aspect of legal practice, and a failure to do so properly, whatever the circumstances, requires a significant sanction, and that was reflected in these protective orders that were made. So in considering what orders to make, the tribunal considered specific deterrence of strengthening the ethical integrity of the solicitor, as they put it. So they ordered an ethics course, and protection of the public, and the aim of general deterrence, so to prevent the rest of the profession doing something similar, and education of the legal profession. So the intention in making a reprimand, fine and ethics course was to deter both this solicitor specifically from doing this again, but also to deter the profession as a whole, not to punish the practitioner, but to protect the public. And of course, an order for costs was made. Now, this next case proceeded in the way that these cases often proceed, with a stage 1 and stage 2 hearing, and both of those decisions are up on the screen there. The stage 1 is in relation to liability. So what has the solicitor done? How bad is it? Does it amount to PM or UPC? And then a stage 2 hearing at a later time to determine what protective orders should be made. So in this case, the Law Society So in this case, the grounds of complaint and orders sought. So the Law Society alleged that the solicitor intentionally misled the LPI when requesting the removal of 2 caveats. They sought a finding of professional misconduct. So the solicitor's client owned a property at Green Valley. This is just a very brief summary of the facts. The solicitor had lodged with the LPI a document requesting the removal of those caveats. And that removal request referred to proceedings in the Supreme Court for the extension of the caveats and orders of the court refusing to extend them and refusing leave to lodge further caveats on the property. It also attached the court's judgments and orders, and the caveats were removed. So the Law Society alleged that the judgment and orders did not, in fact, refer or relate to the Green Valley caveats, and that the solicitor knew or ought to have known this fact. The solicitor admitted these matters and said he had made a mistake, but he said the mistake was not intentional, and he said he was sloppy in what he did. So the solicitor's case was that the errors in that removal request and the solicitor's admissions in relation to those errors led inevitably to the inference that when drafting the document, this is the society's case, led inevitably to the inference that when drafting that document he had acted deliberately and recklessly, whereas the solicitor maintained that he had made a mistake, albeit an egregious one. And the tribunal came to the view that it could not be comfortably satisfied to the Briginshaw standard that this solicitor acted intentionally or recklessly in relation to his lodging of the caveat removal request. His answers in cross-examination were not inconsistent with his position from the outset that he'd failed to give proper attention to what he'd written in the document. And the tribunal found that he gave his evidence openly and honestly. He'd conceded that he'd acted incompetently, but he didn't admit that he'd acted with intent to mislead. And there was no evidence that his actions were part of a course of conduct and were other than a one-off occurrence. The tribunal considered whether the significant errors in the caveat removal request, even if not made deliberately, could constitute conduct amounting to a substantial failure to reach a reasonable standard of competence or diligence. So in other words, whether it's PM. The tribunal held that the solicitor's conduct, which it found was not intentional or reckless and to have been an isolated event, could not be characterised as a substantial failure to meet the standard, and they made a finding of UPC. At the Stage 2 hearing, the tribunal agreed that it would be appropriate for the solicitor to receive a reprimand for its deterrent effect, and the solicitor and the deterrent effect on the solicitor and also on the profession as a whole, and made the point that solicitors in their dealings with third parties must be very careful to ensure they don't inadvertently make misleading representations. So this next case of Clifton. So in this case, brief summary of the facts. The solicitor sole practitioner was alleged to have, without authority, authorised the transfer of money from his trust account to pay debts of the practice, and authorised for 3 false tax invoices to be prepared in relation to 3 of those trust transfers. Now, the evidence showed that all of the trust transfers had been repaid to the trust account. Nevertheless, the Law Society sought an order recommending removal from the roll. Now, the solicitor accepted that his conduct amounted to professional misconduct, and the tribunal made that finding. In relation to the protective orders, the tribunal considered prior decisions and said that ultimately the tribunal must look for guidance to the Supreme Court, which retains its inherent jurisdiction over the legal profession with respect to disciplinary matters. The tribunal held that in many decisions, the Court of Appeal has consistently stated that the appropriate standard for the tribunal to adopt in cases of this kind is to recommend removal from the role. And the tribunal referred to the case of Kumar and the Legal Services Commissioner to the effect that even a temporary use of clients' funds without approval amounts to serious and deliberate dishonesty. The tribunal made an order recommending removal from the role, and the Court of Appeal subsequently made that order. Now, this next case, this case has a stage 1 and stage 2 hearing and a Court of Appeal hearing, decision of EFA. So in March 2021, the tribunal published its headline-grabbing stage 1 decision in EFA. The Bar Council brought proceedings against the barrister in seeking findings of PM, or alternatively UPC, against the barrister, alleging that he had engaged in sexually inappropriate conduct, in that on 21 July 2017, when attending a function attended by barristers' clerks and by invitation barristers, he made sexually inappropriate advances, including gestures, physical contact, and words spoken to an assistant clerk and to another in her presence. So more specifically, it was alleged that just prior to 11 o'clock, the barrister approached the table that the clerk, who he didn't know, was sitting at. And as the barrister approached the table, it was alleged that he stuck his middle finger of his right hand up at another barrister sitting at the same table as the clerk. It was also alleged that in front of the clerk, the barrister then grasped the other barrister's head with his hands and pulled his face backwards and forwards towards his crotch. And it was alleged that the barrister then leaned towards the clerk and placed his left hand on the back of her head and guided her head towards his crotch. Now, that was the allegation. That was not found, in fact. And it was also alleged that whilst he did that, he said words to the effect on the screen there, which I won't repeat. So, apart from the clerk, there were no other witnesses. There was no witness was able to give a direct account of of the incident. The barrister and the other barrister had no memory of critical aspects of the incident because they were intoxicated. But the tribunal was able to view CCTV footage from the evening. So the barrister admitted sticking his middle finger up at the other barrister on the clerk's table. And he admitted that in front of the clerk, he had grabbed the barrister's head with his hands and pulled his face backwards and forwards towards his crotch. And the tribunal found that those allegations were borne out by the CCTV. The tribunal found that it was clear from the CCTV that the respondent barrister did not move the clerk's head towards his crotch. I think he did lightly push her head, perhaps in the direction of the table, but certainly he didn't grab her head and pull it towards his crotch. The tribunal accepted the clerk's evidence that the barrister had said the offensive words. So in terms of characterisation of the conduct, in relation to the interaction with the barrister, the other barrister, the tribunal found that the barrister and the other barrister were good friends and that their interaction appeared to be a bit of a private joke between them. The tribunal said that the interaction between the two of them was clearly not appropriate at a barrister's clerk's dinner, even late in the evening, and it had the potential to offend onlookers, but they said that there was actually no evidence that anyone present that evening was in fact offended by the interaction, including the clerk. But in relation to the conduct towards the clerk, so lightly touching her head and saying the offensive words, the tribunal held that the respondent barrister's words and actions did amount to sexually inappropriate conduct that offended and humiliated the clerk, but interestingly said that it was not a sexually inappropriate advance or any kind of advance at all. The tribunal stated that it seemed from the CCTV footage that the barrister was extending to her an abridged echo of the greeting he had offered to the barrister. He was including her in the horseplay he'd engaged in with the other barrister. And the tribunal said that it was very poorly judged and doubtless on account of the significant level of intoxication. So at the stage 1 hearing, the tribunal found that the barrister's conduct did not amount to PM, but it did amount to UPC on account of it being a breach of the of rules 8A and C of the barrister's rules, which say that a barrister mustn't engage in conduct that's discreditable, likely to diminish public confidence in the profession, or bring the profession into disrepute. So at stage 2, the tribunal issued a reprimand. They declined to impose a fine. They declined to order counselling. They ordered costs. Well, the Bar Council appealed against both of the tribunal's decisions. In respect to the stage 1 decision, it sought an order on appeal that the barrister's conduct constituted PM. And in respect to the stage 2 hearing, it sought, in addition to the formal reprimand, that there should be a fine and an order for counselling. The barrister also filed a notice of contention, challenging the tribunal's finding that he had said the offensive words. So the issues on appeal were whether the barrister had said the offensive words, whether there's a distinct category of professional misconduct at common law beyond what's incorporated in the Act, beyond the statutory definition, that is, whether the barrister's conduct would justify a finding that he's not a fit and proper person to engage in legal practice, and whether the tribunal erred by only imposing a reprimand. So just looking at those one by one. So whether the barrister said to the clerk the words, the court undertook a close examination of the CCTV and was satisfied that the barrister did make the offensive remark, or something very similar at least, because there was no other explanation for the clerk's immediate distress and her complaint to another clerk on the evening, other than it was an accurate reflection of what had been said to her. Whether there was a distinct category of professional misconduct of common law beyond what's incorporated in section 297, well, what this meant was that in these cases, in a lot of disciplinary cases, you'll see reference to the common law definition of professional misconduct being conduct which would be regarded as disgraceful or dishonourable by one's professional peers, and that derives from the case of Allinson, and it's known as the Allinson test. But in this Court of Appeal decision of EFA, the Court of Appeal, I suppose, clarified that there actually does not exist in the common law of New South Wales a distinct category of professional misconduct that's regarded as disgraceful or dishonourable by professional peers, and that's divorced from the test of fit and proper person to engage in legal practice. So they said it's useful. It's a useful test to determine whether or not the statutory definition has been met, but it's not a separate and distinct test on its own. Whether the barrister's conduct would justify finding he wasn't fit and proper to engage in legal practice, well, the court held that conduct that would justify a finding of unfitness to engage in legal practice is not necessarily conduct that must result in such a finding. And the question of fitness focuses not only on the objective circumstances of the conduct in question, but also on the personal qualities of the lawyer in question and other circumstances that bear upon the conduct. So the court took into account the isolated nature of the conduct and found that the tribunal did not err in finding that the barrister's conduct was not conduct that would justify a finding of unfitness. Whether the tribunal erred in its assessment of the seriousness of the barrister's conduct by imposing only a reprimand, well, the court held that saying the offensive words to the clerk elevated the conduct into a new dimension and called for severe condemnation worthy of a pecuniary penalty over and above the reprimand. The court held that the conduct was demeaning, humiliating, inexcusable, and that intoxication afforded no excuse. However, given the significant financial penalty that had already been levelled against the barrister by his insurer, the court held that the imposition of a fine was not necessary in light of the protective, not punitive objective of disciplinary orders, and further that in considering the penalty issue, the conduct needed to be seen in proportion to what it had already cost this barrister in personal, emotional, and financial terms. In particular, the court noted that a level of extracurrial punishment had already been visited on this barrister, including public notoriety, humiliation, 4-year period of anxiety during the investigation, the anxiety of the appeal. There is evidence of a severe impact on his mental health, termination of his marriage, disruption to family, the very significant quantifiable cost in relation to his insurance policy. So his insurance policy premiums and so on had skyrocketed as a result of this case. And also an unquantifiable but real and significant impact on his practice. Now, in this case, it's quite unusual to have non-publication orders, but in this particular case, the court found that the evidence established that if the barrister's name were to be made public, his already fragile mental health would be at risk, and therefore an order restricting publication of identifying information was necessary to protect the barrister's safety. The court ordered that the publication of information tending to reveal the identity of this barrister is prohibited in Australia for 20 years. So the appeal was dismissed and the Bar Council was ordered to pay the barrister's costs of the appeal. Now, this next case is the case of Raphael. So the barrister in this case admitted sexually harassing a young female solicitor in a conference room in the Supreme Court of New South Wales. They were each representing a party in the Supreme Court proceedings. A judicial registrar had directed the solicitor to obtain some further information from her supervising solicitor about the delay in prosecuting their client's case. So the solicitor was sitting in a conference room alone, door closed, while she was trying to obtain that information. Now, the barrister entered the conference room and after referring to the solicitor's wedding ring, said words to the effect, "Won't your husband get jealous because we're spending so much time together? He'll think something's going on." The solicitor became visibly upset and started to cry. So the barrister placed his arm on her shoulder, kissed her on the top of the head and said, "Don't worry, you poor thing." Now, the barrister admitted, and the tribunal found, that placing his arm on the solicitor's shoulder for between 10 and 20 seconds, kissing the top of her head in the context of the comments he made, came within the definition of sexual harassment under Section 22A of the Anti-Discrimination Act. It was an unwelcome act of physical intimacy, and having regard to all the circumstances, a reasonable person would have anticipated that this solicitor would be offended, humiliated, or intimidated by the conduct. Now, the tribunal found that in all the circumstances, including the fact that the barrister made the two comments, the physical contact constituted UPC, as defined in section 296 of the Uniform Law, because it amounted to sexual harassment, and also because it breached the barrister's rules, namely Rule 123, that a barrister must not, in the course of legal practice, engage in conduct that constitutes sexual harassment or workplace bullying. And also Rule 8, so that's the same as for EFA, so discreditable conduct, conduct that's likely to diminish public confidence in the legal profession or bring the profession into disrepute. So the tribunal addressed each example of UPC in turn, so sexual harassment, workplace bullying, and breach of Rule 8. In relation to sexual harassment, the solicitor was a young, inexperienced solicitor. The barrister was an extremely experienced older barrister. There was a vast power imbalance, and his advanced age, the tribunal said that his advanced age does materially detract from the way his behaviour would be viewed. The barrister and the solicitor had never met before, and they were working in a professional environment. The solicitor was upset after having been spoken to by the registrar, and the barrister knew that the solicitor was married because she was wearing a wedding ring. He saw the ring and he made a comment about her husband being jealous because they were spending so much time together. So the tribunal said that they accepted that the barrister's remarks and conduct were intended to console this solicitor, but viewed objectively, they had sexual undertones and involved an overt act of physical intimacy. So viewed objectively, a reasonable person, having regard to all the circumstances, would have anticipated that this solicitor would be offended, humiliated, and intimidated by that conduct. In terms of workplace bullying, that's defined in section 125 of the barrister's rules, as unreasonable behaviour that could reasonably be expected to intimidate, degrade, humiliate, isolate, alienate, or cause serious offence to a person working in the workplace. Now, both the barrister and solicitor were working in the court building. The conduct was unreasonable, and so the tribunal found that the conduct fell within that definition of workplace bullying. The conduct was also found to be a breach of Rule 8 because it was discreditable and it was likely to diminish public confidence in the profession and bring the profession into disrepute. Now, the barrister sought a caution, which is a lesser sanction as opposed to a reprimand, but the tribunal referred to the barrister's initial lack of insight. In his affidavit, he'd characterised his conduct as attempted chivalry, as a misguided attempt to console a younger female solicitor and try to help her. And while the barrister now admitted that the conduct constituted sexual harassment, the tribunal said it was significant that he came to that realisation so late in the day. So the tribunal said that they accepted that the barrister's evidence, which was supported by several referees who knew him well, that he didn't intend to distress, upset, humiliate, or embarrass this solicitor, and his lack of understanding of the potential impact of his behaviour, though, was of considerable concern to the tribunal. The tribunal said that the barrister needs to understand that this kind of conduct is not perceived by the vast majority of women as being comforting, chivalrous, or even vaguely humorous, and that sexual harassment of this kind has the potential to adversely affect a victim's mental health and to dissuade her from continuing a career in law. So they held that the conduct did justify a reprimand and also some education and further counselling. or education and counselling. This next case of Rogers, this was a failure to pay super to a secretary. So this solicitor failed to make payment of employer superannuation contributions payable in relation to the complainant, who is a legal secretary employed on a part-time basis. He failed to issue to the complainant any group certificates or PAYG summaries in respect to her employment. Now, by the time of the hearing, the super contributions had been remedied, but not the PAYG income tax instalments. They hadn't been made. Now, the Law Society alleged this was professional misconduct and sought a reprimand, fine and costs. The solicitor initially admitted professional misconduct and agreed to the orders sought, but at the hearing he withdrew the admission of professional misconduct and sought to argue that it was only UPC. So the tribunal had to determine whether the admitted conduct did amount to PM or UPC and what appropriate orders should be made. The tribunal determined that this conduct amounted to PM for several reasons. It comprised repeated failures over an extended period of about 20 months. The failures were a conscious exercise of robbing Peter to pay Paul. The tribunal held that the failures were deliberate, systemic, and that the solicitor had displayed neither candour nor honesty in his dealings with the secretary, nor the respect for the law and the need to comply with his obligations under it. As is often the case with failure to pay superannuation, the employees usually don't know and haven't been told about it, so that they can make their own determination about whether to continue their employment there. And it's this failure to tell them that I think would have amounted to that lack of candour. So the tribunal held that this was professional misconduct. Declined to issue a fine, said there was little utility in imposing a fine, given the conduct was attributable to a substantial degree to financial pressures of the practice, and so imposing a fine risked making a bad situation worse. He was also ordered to undertake and pass a business management course by a certain date, ordered to also by a certain date, he was ordered to reach an agreement with the ATO for all outstanding PAYG, super and any other amounts. And an order was made that if he didn't comply with those orders for further education and to bring to enter into an arrangement with the ATO, then he would not be permitted to practice as a principal of the law practice until he complied. And he was also ordered to pay costs. Now, this final case of Titmarsh. So in this case, the solicitor admitted gross delay in effecting the transfer of title of land. He first received instructions to obtain probate of a will, including instructions to transfer the land in accordance with that will in January 1996. But by November 2010, so 14 years later, the person who was beneficially entitled to that land had died without any transfer having been effected. He also admitted then gross delay in administering that person's estate, in that he took no action for another 22 months. The tribunal held that this was UPC, issued a reprimand and ordered the solicitor to go on a practice management course, also issued a $5,000 fine and costs. Now, just some of the summary of the key takeaways from these cases. So the first case we looked at in relation to the pressure from your client to quickly sign an affidavit, even though they were overseas. The tribunal said that pressure from clients and embarrassment are not and cannot be excuses for lapses in compliance with your professional conduct obligations. And also in relation to that matter, witnessing documents is a fundamental aspect of legal practice, and a failure to do that, whatever the circumstances, requires a significant sanction. We looked at the case regarding the removal of caveats, and the solicitor who admitted that he'd been a bit sloppy with his removal of caveat request. Sloppy work can lead to disciplinary findings, as was evident in that case. And the tribunal in that case said that in dealings with third parties, especially public entities like the LPI, practitioners have to be very careful to ensure that they don't inadvertently make misleading representations. We've looked at a case concerning misappropriation from the trust account, even although those funds were only used for payment of debts of the practice and were repaid promptly to the trust account. Dishonesty or misappropriation can result in removal from the role. We've looked at a couple of cases concerning sexual harassment, workplace bullying. Inappropriate workplace conduct can result in disciplinary sanctions. Failure to pay super and a failure to meet tax obligations will often result in findings, usually of professional misconduct. A gross delay can result in disciplinary sanctions too. Now, in all of these cases, when the tribunal is looking at what protective orders to make, it's really important for the solicitor to demonstrate, and even actually throughout the complaints process, contrition, insight, remorse. If these things can be demonstrated, then I think it gives comfort to the tribunal or the local regulatory authority determining the matter, if it's being determined in-house, so to speak, that this practitioner gets it. And if they get it, they're not likely to do it again. So thank you. Do we have any questions? So one thing I'm often asked, I think we have 5 minutes. One thing I'm often asked is whether there's a requirement on solicitors to report one another if they think they've breached the rules. And there is actually no obligation to do so unless there is that the only thing that's mandatory to report under the rules is a trust accounting issues. So if there's a suspected breach of the trust account rules, then you're required to report that, but otherwise no. And certainly practitioners shouldn't use the threat of bringing a complaint to try and get some civil liability over the line for their clients. In fact, threatening to bring a complaint in those circumstances can amount of itself to professional misconduct or unsatisfactory professional conduct. Any other questions? Doesn't seem like we do. If anyone has any questions and they want to email them through to me, please do. Another query I sometimes get is what's the difference between a caution and a reprimand? A reprimand is public and it's placed on the Register of Disciplinary Action, which is found on the Legal Services Commissioner's website, and it's there for everyone to see. A caution, on the other hand, would just remain on your own disciplinary record and would not be made public, so it's a lesser sanction that can be issued. And if anyone is facing a complaint, do remember that the Professional Conduct Advisory Panel members are all available to have a chat to you for a bit of guidance by phone. Guidance can be given free of charge up to an hour. And then if you require legal advice and assistance, you can choose to engage. Some of the panel members, such as myself, will act for solicitors in this area, and you can then choose to engage that person. It is very difficult to represent yourself in such matters. It's very difficult to be objective when a complaint has been made about you and when it's your professional reputation at stake. So do reach out and get some help if you need it. Thank you. I think we'll, as there's no questions, I think we can probably finish there. So thank you very much for coming along and listening today. I would be grateful if you could fill in the feedback form, and thank you very much. I hope you enjoyed the webinar.